Well, good morning. For me, anyway, it's morning. We are now doing week 12 of your domestic relations class. And in this week, we're going to be covering post judgment divorcement and divorce matters. So, we've already covered how to terminate a marriage, right? We've done a dissolution and we've done a divorce. We know that a lot of divorces, the majority of divorces, end with an uncontested divorce, which is everybody, after the dust settles, after the complaint's been filed and everybody knows where everyone stands, agree to pretty much everything. We've gone through spousal support. We've gone through child support. Now we're going to say our divorce is final. Everything's done. Even our dissolution is final. What kinds of things can happen in court or even administratively if something from our divorce doesn't go right? It doesn't really work out the way we thought it would. And let's be honest, no one has a crystal ball. Nobody knows what's going to happen in the future. So we try very hard to anticipate issues and speak broadly when we do our separation agreements or when the court puts together an order. But the truth of the matter is there are things that come up. So we're going to go through a few of those things and how the court handles them. Okay? The first is, let's talk about dissolution. In a dissolution, everybody agrees. Remember, it's a joint petition for dissolution. Everyone shows up to the party together with an executed separation agreement. We've agreed on everything. We're not fighting. What if you find out after your dissolution hearing, after the court files its order granting your dissolution and terminating your divorce, what if you find out that everything wasn't exactly the way you thought it was? Maybe there was some fraud. Maybe your former spouse hid the snowmobile that he transferred to his brother for $1 3 months before you guys filed for dissolution. That's fraud. That's hiding an asset. Or what if someone finds out that you were coerced or you were promised something if you would go through with the dissolution? Those are all basis for fraud. If you don't like the terms of your separation agreement because you discover there's been some kind of fraud, or you realize you were promised something and you didn't get it, which is enticing you into a contractual relationship, this separation agreement. And lots of times that happens where one spouse will say to the other, look, I know it's not in the separation agreement, but if you just sign off on it, I'll make sure that I get life insurance and you're the beneficiary. Or I'll make sure that you can stay on my health insurance. Or I'll make sure that I pay the house payments. Something like that. It's not in the separation agreement, but you wouldn't have signed the separation agreement if you hadn't relied on a misrepresentation. You then have the opportunity to petition the court and say, look, fraud was committed here. I was either fraudulently enticed into this contractual agreement, the separation agreement, which again is a contract, or somebody lied. And so when we split up our assets, I didn't get my fair share because I didn't know this even existed. The court can reopen your dissolution, hold a hearing on the hidden asset, hold a hearing on the fraudulent enticement or the coercion, and can then modify the separation agreement. Usually, there's a spanking involved with that. Usually, if you hid the snowmobile, let's say, and the court finds out about the snowmobile, if you had just disclosed the snowmobile at the outset, you would both be entitled conceivably to 50%. Now the whole snowmobile plus interest is going to the other spouse. The value of the snowmobile plus interest plus whatever spanking the court wants to give you is going to the other spouse. So the moral of the story is, don't lie. Don't commit fraud. Do it on the up and up. If you're working in an office and a client goes, oh, I got a sweet deal and he doesn't even know I'm doing this, or she doesn't even know I'm doing this, you got to stop them right there. And if they don't want to listen to you, you say, I'm sorry, I can't represent you anymore because I'm not going to be a part of fraud. Okay? So that's our first instance of post-judgment matters. The most common deal with child support and visitation, right? The fraud stuff very rarely happens. But when you have children, you can't foresee the future. You don't know if you're going to remarry. You don't know if you're going to lose your job. You don't know if you're going to move. You have no idea. People who tell you they do know, they're lying to you, and they're lying to themselves. So let's talk about child support first. When the marriage is terminated and there are children that are born as issue of the marriage, there is going to be some kind of child support order based on, remember how we did the calculation, we add mom and dad's income together, we figure out what percentage of that whole is mom and what percentage of that whole is dad, and then based on whatever parenting arrangement you have, that will be who pays whom, and it may be reduced because of whatever special circumstances you may present to the court that they accept. Okay? When there is a substantial change in circumstances, you can go back to court and you can tell the court, look, this child support calculation was good at the time, but we've had a substantial change in circumstances. Somebody's lost their job. That is our biggie. Or somebody got a substantial raise, got a new job and got a substantial raise. Lots of times, typically mom will remarry and will not work or will not work full time. And then she will say, well, I'm entitled to more child support because those percentages are now off. So what does the court do with these? First of all, unless there is a 15% change in the amount of support that is going to be paid, the court doesn't even look at it. That's how we determine what a substantial change is. It's not a 15% increase or decrease in income. It's after you do the child support calculation with whatever changes you're talking about, there's a 15% change in what that child support payment is going to look like. That's a lot. Usually these are situations where someone's lost their job. Usually your child support stays pretty steady most of the time that you're paying child support. Again, because that 15% threshold is really high. But if somebody loses their job, obviously that's going to result in more than a 15% change in the support that's paid. So the court will then hear the motion, look at the facts, and make the adjustment. So that's called a modification of child support. Now, you can do that through the court, but you can also do it through the Child Support Enforcement Agency, which is called an administrative way of handling things. There are pros and cons to both. If you go to court, it's done pretty quickly. Usually within 30 days of when you file your motion asking the court to modify child support, that support will be changed. It costs money though. You're going to have to pay a filing fee and you're going to have to pay your lawyer. So you're looking at roughly $1,000 to $1,500 in order to effectuate this support modification. If you've lost your job, it's pretty hard to justify that, right? So what a lot of people do is choose option 2, which takes longer, which is you go to your case manager at the Child Support Enforcement Agency, you give them all of the supporting documentation, and they make the modification. It doesn't cost you anything, but it takes a lot longer. Depending on the case manager you have, you really need to sort of ride the case manager and say, hey, you need to modify this. Understand that while your modification is pending, you still owe child support in the amount that's ordered. If you go through the court, they will usually backdate the order to the date that you filed your motion for modification. But let's say you've been unemployed for 3 months. You thought you were going to get a new job, you had enough money saved, you're paying the child support, and then you file your motion to modify. Those 3 months that you waited, you still owed that dollar amount. The court will backdate and take care of any kind of arrearage, any kind of non-payment to the date that you filed your motion. With the Child Support Enforcement Agency, sometimes they do that and sometimes they don't. I'm going to be honest, it just kind of depends. And you have to be really vigilant and you really have to fight. That's the best way to describe it. But out of pocket, you won't have any out of pocket. Okay? If you have a situation where you have a child who has an accident or develops an illness, that's also a basis for modification of child support. That also can be a substantial change in circumstances, where the court will not just look at the child support guidelines worksheet, but will also take into account the added medical expenses or care expenses that are associated with whatever the child's issue is. Those are thankfully are very rare. But that is a statutory reason why the court will modify or is able to modify child support. You have to go through the court for that. You can't go through Child Support Enforcement Agency for that. Okay? So that deals with modifying child support. And by the way, people try to modify child support all the time. And lawyers need to tell their clients when they come in, I'll run the numbers, but if it's not a 15% change, I'm not going to do anything. And clients get pretty mad about that, and some lawyers just file it. They just file it and let the court be the bad guy, and they get paid. So, not really the best thing to do, but a lot of lawyers do that. Okay. What if we need to modify custody or visitation? Again, a substantial change in circumstances becomes our standard. So what does that mean? Well, let's say we have a parenting agreement where we have a shared parenting agreement, which I hate. And one of the parents moves outside of the radius where a shared parenting plan will work. Well, is that a substantial change in circumstance? Yeah, because now the child will have to get up 45 minutes earlier, let's say, to go to school. So we need to change who the child is staying with more of the time on school days. That's a pretty common thing that happens. It is not a reason to modify visitation that mom got remarried or dad got remarried or has a live-in girlfriend or boyfriend or whatever. Unless you can show that the child's best interests are not being met. For instance, the child has to stay home and babysit new infant sister or brother, and the child is 8, 9, 10 years old. Or, dad is off with the girlfriend and is not taking care of, neglecting the child. Where sleeping arrangements aren't going to work because with the new relationship and the blended marriage, we've got all these kids and there's no place for this child to sleep. You've got to show something pretty substantial. In and of itself, the fact that you just don't like your former spouse's new significant other, that doesn't work. There's got to be an overriding substantial change in circumstance where the child's safety, health is being affected, and or the arrangement that you have because one parent has moved is no longer tenable. Lots of times parents just work this out. Lots of times parents will say, hey, I see, you're moving to a new house. It's not going to work for you to take the kids Monday and Tuesday night, but how about if we add a weekend in? And they make their own arrangement for what works. And that's generally the best way to do it, right? You really don't want some stranger who doesn't know your world coming in and making a decision on how you're going to run your world. It's better for you to run your world. When you cannot agree is where there's a problem. And also, this is what always happens. Everybody's getting along. They've made the separation agreement work for them. They've made modifications. They've made agreements. And then one of the former spouses gets a new significant other. That mom doesn't want, my kid's not going to call another woman mom. Or my kid's not going to call another man dad. That's a problem. And that's when people stop getting along, and that's when you start seeing the motions to modify parental rights and responsibilities filed because the parents aren't getting along. And usually it's because they're jealous. It just is. There have been lots of cases recently where mom and dad get divorced, they've got a shared parenting plan, or they've got some kind of visitation order, and it turns out that maybe mom has a relationship with another woman and dad doesn't approve of that and doesn't want their child exposed to that. That in and of itself, the courts have said, is not a substantial change in circumstance. You do not get to dictate your former spouse's intimate lifestyle. You just don't. Unless it affects the child. Some people will say, well, obviously that is affecting the child. And when I say affecting the child, I mean abuse and neglect. Those are the biggies. If you can show abuse and neglect, then with a new partner, then yeah, absolutely. Absolutely. Usually there will be a guardian ad litem that will be appointed or reappointed if it's been a recent divorce and you have you have a guardian ad litem from your divorce. They know the kids, they know the families. They'll just continue what they're doing. If it's been a while, then you'll have a new come in. By the way, remember that every separation agreement that is an agreement, either a dissolution or an agreed separation agreement after a divorce is filed, there is always, always, always the provision that you go to mediation before you file a motion. So with modifying custody, visitation, parental rights and responsibilities, all those are synonymous. Most of the time you have to go through mediation first. You have to go to an individual who will then say, what do you want? What do you want? Let's put it together. And then everybody will sign off on a modification and it'll go and get filed with the court. If mediation is unsuccessful, that is when you will file a motion with the court asking the court to intervene. Okay? What happens when one parent just relocates? Just moves to another state or even another city, somewhere outside of the county where the termination of the marriage happened. So let's say that I get a divorce in Trumbull County and I decide to move to Franklin County and I decide I'm taking my kids with me because they're my kids. Not so fast. Not so fast. In order to make sure that the children's worlds are not totally disrupted, if one parent, even the parent that doesn't spend a lot of time with the children or the non-residential parent, is moving, especially outside of the county, you need to file what's called a notice of relocation or intent of relocation. Okay? You give notice to the world that it is your intent to move outside of the county where the termination took place. Okay? Now, for the non-residential parent, it's really not that big of a deal. Generally, when we have a standard order of visitation with a non-residential parent, it's every other weekend, every other holiday, one midweek visitation. So perhaps the midweek visitation goes away because, especially during the school year, because it's too far away for it to be practical. And so usually nothing really happens with a non-residential parent relocating, but with a residential parent relocating, sometimes you really have trouble. You know, if you have a shared parenting plan, forget it. You're never going to relocate. You signed a contract. You said these kids are going to have a stable life. You said you were going to be able to work it out. The court took you at your word. Done. Nobody's relocating. And if you are going to relocate with a shared parenting plan, then you better go to mediation and you better put together a long distance visitation order. Because that's the only way it's going to work. You're no longer going to have shared parenting. But if you have like a modified standard order or a standard order of visitation and you're the residential parent, you can't just pick up and move. The non-residential parent has the right to have a relationship with their children. So if you're moving and you give notice of intent to move, you better show that grandma's going. You better show you're going someplace where there's a lot of family. You better show that, you know, you're getting a job, but it's in a place where there's a lot of family support, because if you are removing children from a stable situation and moving them to someplace where they don't know anybody and the non-residential parent is right here and can keep the kids are going with the non-residential parent. That's what's going to happen. Unless the non-residential parent says, I don't want them, you're going to lose primary custody of your children if you move a distance away from the non-residential. Now, if the non-residential parent doesn't care, a whole different ball of wax. But, you know, if the non-residential parent says to the residential parent, hold your jets. My mom's here. My siblings are here. These kids have a relationship with my family. You're moving them 400 miles away? No. You're taking them away from their school and their extracurricular activities? No. And either you're not going to move with the children, or you're not going to be the residential parent anymore. And that's just how it works. There's no perfect way. You don't have a crystal ball. You don't know if you're going to lose your job and then have to move to go get a new job. You don't know these things when you terminate your marriage. So these are things that the court needs to modify to make sure that things go nicely. Okay? So let's talk about enforcing orders of the court. Child support orders, visitation orders. The court has the ability to hold parties in civil contempt. Civil contempt is different from criminal contempt, right? If you are caught speeding and you don't show up for court, the court will hold you criminally in contempt. A warrant will go out for your arrest, and you're going to spend a night or two in jail. That's criminal contempt. Contempt is where you're thumbing your nose at the court, saying, I don't really care what you say, this is what I'm doing. Civil contempt is kind of a hybrid of criminal and civil kind of penalties. Domestic relations judges don't have the authority to hold someone criminally in contempt, but if you thumb your nose at the court can put you in jail, make you think about it, and then make you comply with the order. Okay? So it's kind of a hybrid of civil and criminal penalties. So let's say that I don't pay my child support. What's going to happen to me? Well, depending on how long I don't pay my child support, The Child Support Enforcement Agency may get involved and the court may get involved. The Child Support Enforcement Agency has several administrative tools in their toolbox to make people pay their child support. The first is they can have the state revoke your driver's license. So you don't have driving privileges anymore until you pay your arrearages. Usually you have to be in substantial arrearage, which can be anywhere from 6 to 12 months in arrears. Some case managers will do three months, and then they'll start the process of taking away your driver's license. I've always thought that that's kind of a weird thing to do, because how are you going to get to work to pay your arrearage off? It doesn't really make much sense, but it's just a tool that the Child Support Enforcement Agency has. Every child support enforcement agency also has a criminal prosecutor on staff who only does criminal failure to pay child support cases. And these are the people whose faces you see at the post office, who are, the deadbeat dads. I know that there are deadbeat moms too, but you'll see posters of deadbeat dads who haven't paid their child support in years. And so there are statutes out there that allow the county to criminally charge someone for criminally neglecting to pay their child support, and they can go to jail. So if the Child Support Enforcement Agency can't get someone to pay, they can make a criminal referral to the prosecutor's office. Also, one thing that the Child Support Enforcement Agency can do is put a lien or a hold on any tax refund that the obligor has. So if I'm working and I'm expecting to get a tax refund, and I'm behind on my child support, I'm not going to get a refund. The Child Support Enforcement Agency is going to put a hold on it, put a lien on it. It's automatically going to go towards your arrearage for your child support. One kind of sticky matter that we get into with that is, let's say dad is the obligor. He hasn't paid his child support. He's significantly in arrears. But dad has remarried. And so new wife and dad are filing jointly for their tax refund. And the entire amount of the tax refund, even the refund that was due to the new spouse, goes to pay the arrearage. Well, the arrearage belongs to dad. It doesn't belong to new spouse. We never take into account the income of a new spouse when we're calculating child support or when we are putting a lien on it. So new spouse will have to go to the IRS and file paperwork saying I was an innocent spouse, I had no idea, they took my tax refund. It's a pain in the tushy, really. And so if you're in arrears for your child support and you're remarried, file separately. That's the best thing to do. Okay? So that's one area where child support, you can try and enforce child support. You can also do it through the courts. So let's say that my former spouse owes child support and is significantly in arrears. I can file a motion with the court saying, look, do something. Hold my former spouse criminally or civilly in contempt. Find out what's going on. Typically what happens is a magistrate will hold these hearings, and the obligor will come in and say, look, I'm doing the best I can. I lost my job. I've got a new job. I know I'm in arrears, but can we modify the child support? Lots of times you kind of get the opposite effect when you file a motion to enforce child support, because the magistrate will say, we live in Reelsville here. I'm not going to make him file a separate motion to modify when these are the facts. And so a new order for child support will go on, and usually it's less than what you originally had, but hopefully you'll at least start getting child support. Okay? With respect to visitation and custody, sadly, we have a lot of cases where mom and dad aren't getting along. Maybe mom has said, you're not seeing the kids, you haven't paid my child support, so you're not seeing the kids. By the way, you are not allowed to do that. Those are two separate issues. You never mix them. And dad says, I've had it, I want to see my kids, shows up at school, takes the kid. Usually, the police will come, take the child back. It's really wonderful for the child, by the way. You'll end up in domestic relations court trying to figure this out. If you cross county lines or if you cross state lines with the child, you now move into criminal land, not just state criminal, but also federal criminal land. And you're going to be facing criminal charges for kidnapping. The better approach is to go to the court, tell the court, hey, she's not letting me see my kids. Please hold her in contempt. And what the court will do if you do it right and you don't show up at school and take your kid, is say, you're right. You haven't seen your child for 3 months. Guess what, Mom? The child is now moving in with Dad for 3 months. And sorry, but you can't make up your own rules. So that's how that usually works. Okay? The important thing I want you to remember is we have administrative remedies and we have court remedies. Administrative, at least for child support, you can go directly through the Child Support Enforcement Agency. And the Child Support Enforcement Agency can, on its own, try to collect arrearages. The court usually will be quicker. And when you especially have visitation issues where one parent is withholding visitation, you got to go to court. But we anticipate this. When you terminate a marriage, again, time doesn't stop. We don't say, oh, well, I guess, everything will be wonderful now and have a nice life. The court retains jurisdiction over those children until they reach the age of majority, which means they reach 18 or they graduate from high school, whichever comes later. The court has jurisdiction over them. If you mess around with the kids with things like kidnapping, withholding visitation, abuse and neglect, they don't have very much patience for it because the judges are responsible for those children. The courts are really not there for the adults. You, as an adult, made your decisions. You made your decision to marry, you made your decision to have children, you made your decision to terminate the marriage. Those children are the innocent bystanders in the entire process. And so the court is vigilant in making sure that their needs are met. Okay? All right, that's it for this lecture. Please do the discussion and the assignments. And if you have any questions, as always, reach out to me. I'm happy to answer them. Thank you.